Welcome to the Space for Diplomacy podcast by Spaceport Sarabhai, India's space policy think tank. I'm your host, Susmita Mohanty. This podcast series features conversations on far-ranging topics such as geopolitics, tech diplomacy, international cooperation, and all things space. Today I'll be speaking with Professor Stephen Freeland, who is joining me for this conversation from Sydney. We hope to discuss, among other things, the Outer Space Treaty, the Moon Agreement, competing visions and legal regimes, rules-based governance, geopolitical rivalry, and lunar futures. Professor Freeland, welcome to the Space for Diplomacy podcast.
Oh, thank you, Susmita. It's an absolute pleasure to be here.
Stephen Freeland is Emeritus Professor of International Law at Western Sydney University and co-principal of a space law firm, Azimuth Advisory. He also holds adjunct positions at universities around the globe. Prior to becoming an academic, he had a 20-year career as an international commercial lawyer and an investment banker. Professor Freeland was a member of the Australian Space Agency Advisory Board and has been an advisor to many governments on issues relating to national space legislative frameworks and policy. He represents the Australian government at UNCOPUOS and is chair of the working group on legal aspects of space resource activities. Professor Freeland, let's begin with the Outer Space Treaty. Signed in 1967, it remains the foundational instrument of international space law, but nearly 6 decades later, given today's radically different geopolitical and technological landscape, how effective really is the OST? Does it need reinterpretation or updating or even an overhaul?
That's a great question. And it's a question that I'm often asked. Many people have said the paradigm of space has completely changed, as it has, since the days when the principles that are codified in the Outer Space Treaty were agreed in the early 60s. Space is a completely different visual, it's a completely different practical, it's a completely different cultural space than it was in those early days of Cold War, where essentially you only had, in the beginning, 2 main space actors. They were protagonists in a geopolitical conflict, and yet they both realized that they were the only 2 players in town. And so the 1967 treaty, which, as I said, codifies principles that had already essentially been agreed in the early 1960s. The foundational ideas of non-appropriation and peaceful purposes and freedom of access. The 67 treaty was the reaction of the United States and the then Soviet Union, understanding firstly, that the international community wanted there to be a set of rules because there was great fears and concerns about what space could be used for, given the geopolitical time. But also it was in the interests of both the United States and the then Soviet Union to also have some rules because, to be honest, neither of them knew who was going to win the race, so to speak, that was going on in the 1960s, this incredible development of technology and capabilities and ambitions amongst both those countries, because space was seen not only as an extension of military capability, but of prestige and power, etc. So it was important and crucial to have a set of rules then codified in a treaty. And the 1967 treaty, when it was put together, was a remarkable document. So in answer to your question, though, many people have said, well, things have changed, it's obsolete, it doesn't cover what's going on now, we need to completely change it, or in fact get rid of it and put something else in there. That is a proposition that I would completely disagree with. From my perspective, given all these incredible changes in space, the actors, the activities, the economics, the politics, the capabilities, all those incredible changes, and yet from those early days, even prior to the Outer Space Treaty until now, humanity has garnered so many benefits from space. In essence, to put it simplistically, space has worked, notwithstanding all the changes. And one of the fundamental reasons why space has worked is that we have a set of foundational principles to which every space activity must comply. Even activities that we contemplate now that were never thought about at the time of drafting. So I would say to you, the Outer Space Treaty and its foundational principles, and then everything that's built from it. There are subsequent treaties, there are lots of other UN-related documents, there are lots of norms of behavior, there are lots of customary international law. All of that feeds off from the Outer Space Treaty. I would say to you, the Outer Space Treaty is even more important now than it was at any time in the past. It served us really well, it's serving us well now, and it continued service in the future. You only need to go to any meeting of UNCOPUOS and literally every country at COPUOS will, as part of their statements, reiterate again and again that the Outer Space Treaty and the principles that it defines represent the cornerstone of all activity. Of course, things are changing. Of course, we need to add to these principles because they don't cover necessarily all of the specifics of activities that, as I say, were not in the contemplation at the beginning. Of course, we need to add to those principles, but in the end, everything revolves around the centrality of the Outer Space Treaty. We add more to it, but we never, in any sense, compromise the need to adhere to those principles. It's more important than ever. So, the assumption in the question is that, it doesn't need an overhaul, doesn't need reinterpretation. Of course, states will look at the treaty in different ways given the new types of activities, but those foundational principles will apply notwithstanding anything we do. So, I think we need to ensure even greater adherence and compliance, but of course we need more to add to the certainty and the specificity of new types of activities.
One of the aspects of the OST has been, or was, back in the 60s, to prevent nuclearization, militarization of space, which I think has become relevant yet again, given the geopolitically volatile atmosphere that we now inhabit. I understand that Australia has set up a space force. India set up a space defense agency in 2019, I believe. With this new uptick in military interest in using space assets, how do you think the Outer Space Treaty is well designed to protect us as things stand today?
It's a difficult question, but I would just take the assumption in your question and maybe just challenge it a little bit. I don't think it's necessarily true to say it's a new uptick in interest in the military uses of space. Remember that the Sputnik 1957 mission, which really, in a sense, encapsulated the need for a legal framework, which then developed through the United Nations into what is now the treaty. At that time, the protagonists saw space and saw missile technology as an extension of their military capability. And so space was seen by many who were involved in those years as part of the military capability, remembering the difficult geopolitical times we were. And it's true to say, notwithstanding that many have said this is unfortunate, it's true to say that space has been used for military purposes, terrestrial military purposes, almost since the beginning. And of course, I know, Susmita, you know a lot about those types of activities as well because of your research. So space has always been seen at least by certain quarters, as the main focus of it being an extension of military capabilities, an extension of national security interests, an extension of need-to-know basis only. We know, of course, that that's just one aspect. It's an important aspect, but it's just one of many different aspects of space. All the other voices of space, the scientific community, the commercial community, the diplomatic community, the cultural community, and the indigenous perspectives, all of those other things are also relevant for space. And as I say, humanity has benefited greatly. So the Outer Space Treaty, with its fundamental principle about cooperation, about mutual assistance, about due regard, of course was conceived at a time when the United States and the then Soviet Union were never going to agree to something saying there could be no military activities in outer space. There is agreement about the use of certain types of weapons. There is agreement about the exclusively peaceful nature of activities on the moon and other celestial bodies, but it would have gone against their own perceived interests, that of the two protagonists, to expressly say no military activity. So instead, we have this doctrine of peaceful purposes being an undertone of the Outer Space Treaty. That in and of itself is a powerful thing, but there are different interpretations historically about what peaceful purposes mean. Some have said peaceful purposes means you can have no military activities whatsoever. That, firstly, does not accord with history and the way that states have interpreted the Outer Space Treaty and interpreted that provision of peaceful purposes because, as I say, space has been used a lot for military purposes. But secondly, you can have military uses of space that are also peaceful. For example, verification by satellites that countries are complying with the non-proliferation treaties and things like that. Obviously a military activity, but obviously you could also argue for peace purposes. So it's more complicated than that. The danger is that people misinterpret this use of space for military terrestrial purposes and then ratchet up with the establishment of space forces or whatever, but more with the rhetoric of competitiveness and geopolitics. They ratchet it up, and the danger will be that certain quarters perceive space, one, as an area of what some have called a war-fighting domain, that is, an area where conflict, armed conflict in whatever shape or form, can take place, a theatre of conflict, which it hasn't been, although it has been used to support armed conflict on Earth. And secondly, as an extension of that, this idea that we need to weaponize space, that we need to create areas of exclusion and protect our own assets. In 2001, before September 11, ironically, a commission led by Donald Rumsfeld in the United States, and Donald Rumsfeld went on to become Secretary for Defense in the Bush regime. The Rumsfeld Commission, in about January or February 2001, was concerned about what it called a space Pearl Harbor, given that the United States was certainly then the predominant force in space and therefore was vulnerable to an attack. And that idea of the need to protect what we have in space, as well as the competitiveness, has led various countries, and there are more than one of them, to look at developing weapons technology and more, if you like, invasive and aggressive military capabilities in space. That is the danger. Of course, it would be wonderful from an altruistic viewpoint for there to be no military uses of space whatsoever. But given that it's happened since the beginning, really, and yet space has worked, that would be unrealistic. But we need to avoid a ratcheting up from there. Those that say, for example, that it's inevitable that we're going to have a war in space, and therefore we need to prepare ourselves for it. Firstly, it's not inevitable at all. Secondly, it's contrary to all the legal principles for it to happen. And thirdly, if you keep on saying that, it becomes a self-fulfilling prophecy. And so we need to counter those voices and say, well, in fact, it's not inevitable. And in fact, no one would win in a war in space. Everybody would lose, humanity would lose, and those involved in the conflict would lose. And so there are real reasons why, notwithstanding the military uses of space, which in a sense we can't avoid, that we must not allow that to be ratcheted up further.
Professor, the rules-based international order that was set up after World War II is being challenged at many levels, especially by the second Trump administration. Recently, President Trump signed an executive order aimed at fast-tracking deep seabed mining, bypassing the UN Convention on the Law of the Sea. Do you see this move as part of a broader legal and geopolitical strategy that could also extend to space resource governance? And how do you see Trump's international doctrine impacting space diplomacy at large?
Yeah, I mean, I don't think I want to comment on particular countries and their diplomacy, but it is true to say that space is becoming far more complex. We operate in a very, very difficult and complex geopolitical environment. Achieving consensus on the big issues and achieving multilateral agreement on big issues is almost impossible, although I think UNCOPUOS is making great progress notwithstanding. But this complexity and this perception of competitiveness and the idea that, again, that we need to be the biggest and the brightest and the first and the fastest, and we need to do this in competition to you, has led to changes in the way groups of countries or certain countries look at space. My own personal view is that notwithstanding this, that we have more in common in space than we have differences. And we have more at stake in common. If we get it wrong, then we have the opportunity to prevail in complex situations. Of course, that's easy for me to say. This is a difficult geopolitical climate we're in. Rhetoric is important. And it's true that changes in policy do make things more complicated. So, for example, certain countries may have particular policies on resources, the area that I have the privilege of chairing the discussions at the UN. They may have different policies now or in the future, given changes of administration, given changes in the geopolitics, given changes in technology. That makes life more complicated. But it also means it's even more important that we're all in the same room talking about it, that there is this dialogue. People often scoff at the idea of having everybody in the room. The UN system is slow, it's frustrating, it doesn't achieve anything. But I would retort to that without being an apologist for the UN system. I'm not a UN person, and there are many problems with the system. But where would we be without that multilateral dialogue? In the space arena, where would we have been without UNCOPUOS? Notwithstanding all the problems of geopolitics, this treaty regime, which, as I said, means that space has worked, and all the other documents, all the fact that everybody understands the centrality of fundamental norms, even though there are problems with some of the interpretations, but the fundamental centrality is there, is important. And so changes of policy come and go. Administrations come and go. It makes life more complicated. Some would say, it makes life more interesting. But in the end, there, by and large, has been a relatively stable understanding of the rules of the road. The need for getting on with it without creating too much by way of conflict situations or perception. Of course, I sound like a bit like an optimist. I think I'm being a realist, because the alternate is if we alter our policies and our approaches to space so radically that we cross certain red lines, then, as I said, everybody will suffer. There is no winners in that. And I think, notwithstanding changes of policy by administrations and rhetoric, there's an underlying understanding on that there is more, we have more in common in at least adhering to certain basic fundamentals. The details can change a bit, but the adherence is important. We have more in common in doing that than going in the other way.
Let's talk a bit about the two new blocks that are emerging as far as lunar exploration is concerned. We have the US-led Artemis Accords, and we have the Sino-Russian International Lunar Research Station project. How do you see these two initiatives interacting or even competing in the legal and political shaping of lunar governance?
That's a really good question. I see them both interacting and competing. I see there being the need and the understanding for a fundamental level of cooperation, may not be the right word, but cooperation or, working together in some way, shape and form. But I certainly, as you quite rightly say, Susmita, there's certainly a great degree of competition and more. In the work that I do, which is sharing the discussions, and we're looking to create the principles, building on the Outer Space Treaty and the legal framework that already exists, develop more principles that are specific to the undertaking of what we call space resource activity. You get inputs from all of these different areas. You get inputs from the Artemis country. You get inputs from the ILRS country. You get input from the Moon Agreement countries. And I know India, not a part of the Moon Agreement, but it's a signatory and it has a stake in it. You get inputs from other areas, civil society coming through the states, in industry coming through the states. So from the work I do in creating the rules, it's actually, I think, a positive that you get different perspectives. Obviously, each block is going to say, well, don't listen to anyone else. My view is the prevailing view. It's the best view. Just copy-paste what I've done. And that could be the way that multilateral arrangements and rules of the road should look. Each of them are going to say that to a certain degree. But in the end, there are good things to take from all of those inputs. It's like a mulligatawny soup or a box of marbles. We have so many marbles, and we need to pull out the ones and see how they meld together. So I actually think it's positive from the work that I do that you have the different perspectives, because everything is complex. But the flip side of that is we need to find an arrangement that everybody in the end agrees to. Nothing, I think, could be more dangerous than to have various groups of countries, and of course, in some cases, they're companies as well, but various groups in the resources area, let us say on the moon, in close proximity, looking to do the same things in the same areas, and in their mind's eye, operating under different rules. Nothing could be more dangerous. Nothing could perhaps give rise and presage misunderstandings, miscalculations, and worse. And that, therefore, notwithstanding the competition, it's in their interests. And I think there is a recognition of this, although perhaps not as openly, but there is, in the interests of all of those sides, the idea of having common rules of the road. So there is an element of predictability and understanding, and as is necessary, let's say in emergencies, cooperation between all of them. Then, of course, they'll get on with it. They will compete. They will still try to be the biggest and the best. But if that is done with an underpinning of at least some common rules of the road that they've all had the opportunity to contribute to. They have some ownership in it. They've had the ability to have their views expressed and heard. There's been hard bargaining and negotiation, but we've reached a finalization of some set of principles that they can all agree and abide and adhere to. Then I think we make any future activities, and particularly in relation to space resource activities, if and when they take place on a larger scale, we make that a much more peaceful and beneficial basis. Everything has risks. My mantra in all the work I do in space is that whatever we do, we have to maximize the benefits and minimize the risks. And I think that's what, notwithstanding the competition, we're trying to do, but to find some sort of common framework.
Unlike the 1967 Outer Space Treaty, the 1979 Moon Agreement has very few signatories and very low ratification rates and conflicting viewpoints on resource extraction. So we have countries like Australia that have signed the Artemis Accords and ratified the Moon Agreement. We have countries like India that have signed the Moon Agreement but not ratified the Moon Agreement and signed the Artemis Accords. And we have countries like the United States that leads the Artemis program. There was an executive order by the president in 2020 categorically rejecting the Moon Agreement and emphasizing that the US does not view outer space as a global commons. So I think my question to you is, how do countries like India and Australia that have signed the Artemis Accords and have signed or ratified the Moon Agreement align conflicting legal positions in UNCOPUOS and beyond?
People say they are conflicting legal positions, and of course, as you've quite rightly done, you can make arguments to say that they might conflict. But let me put the alternate view, not that I'm subscribing to either of them, but for example, in the case of Australia, and obviously I understand our position. So Australia, I think, was the first of the Moon Agreement parties that was also a signatory of the Artemis Accords, because it was one of the foundational signatories, the first eight. Other parties, Mexico and Austria and the Netherlands, are now also in the same position. And as you say, India, as a signatory of the Moon Agreement, is also a signatory to the Artemis Accord. And at the time Australia did this, people were saying, how dare you? This is outrageous. These are two conflicting things. This is academics talking. That's what academics are paid to do, of course. But the reality, Susmita, you and I both know well, international law is not made by academics writing journal articles. International law is made by states for states. And when the Australian signed on to the Artemis Accord, having been a party already to the Moon Agreement, firstly, they made many statements publicly declaring that they saw that there was no inconsistency between the two. Okay, of course, you would expect them to say that. But not one country stood up and said that, you are doing something that is unlawful. Not one party of the Moon Agreement said you are breaching your obligations under the Moon Agreement by doing this. It was generally accepted. As I said, other countries are now in the same position. India is in a similar but not exactly identical position. So from a legal perspective, if one wants to drill down to it, it's very difficult to say that these are conflicting legal positions. And remember, of course, the Artemis Accords is not a legally binding document anyway, putting that aside. But of course, people will have different views. But people had different views about space resource activities 10 years ago anyway. I know the Artemis Accords is about more than space resource activities, but that's the activity that seems to galvanize most interest. But I can remember 10 or 15 years ago when certain delegations at COPUOS mentioned the idea of the exploitation of space resources in their statement. And other countries, other delegations would say, to the effect of, how dare you mention that? This is an issue that, is not part of our discussion. It shouldn't be discussed, etc. There was a value judgment that we shouldn't be engaged in these sorts of activities. Now, some people still have that view, and I'm, again, express no view given that I'm the chair of the discussion. However, if you look now at the discussion at the international level, where the legal frameworks are developed, where the law is being developed, no one is saying that. No one is saying that. Everybody accepts, for better or for worse, everybody accepts that these activities are being contemplated. Again, it's still a big if as to when this might happen. And instead, the focus has moved from that initial, if you like, outrage by some to, all right, if this is going to happen, let's formulate ideas that, as I said before, maximize benefits, minimize risks. So at that international level, at the lawmaking level, one could argue that, in fact, these aren't conflicting viewpoints. And in the countries, I'm sure India and Australia and others will strongly adhere to the fact that they haven't put themselves in a position of conflicting legal obligation. Again, also noting that the Artemis Accord is not binding anyway, but still, the point is well taken. But of course, there will always be commentators who disagree with that. But what I've learnt is, of course, commentators are interesting and it's important to get views. But where the law is made, that is a different set of circumstances, a different set of perspectives. And so I think we have to be careful to prejudge or to form views about legality or non-legality of things as they are evolving. Obviously, some things are straightforward, but nothing is entirely black and white, as long as there is a adherence to the fundamental principles, as I've said.
I think it's good, Professor, that you pointed out the fact that Artemis Accords are not legally binding. They're essentially a baseline code of conduct between countries that have signed it and the United States. And this code of conduct was essentially drafted by NASA and the US State Department just before, I think, towards the end of Trump's first term. Let's talk a little bit about President Obama's term. And in 2015, U.S. Space Resource Exploration and Utilization Act was signed into law by President Barack Obama. And this particular law provides a legal framework for American companies to mine and own minerals from other celestial bodies. So how does the general understanding of the global commons account for this kind of unilateral legislation by a country? And there are other countries, too, that have passed a similar law, such as Luxembourg, which doesn't have a significant space program, but is interested in the idea of space resource mining.
It's a really good question. There are a couple of things to respond there. Firstly, your point about the global commons and your previous question that the executive order under the Trump administration, Part 1, expressly said that the United States will regard space as a global commons. If you look at the way space is governed, it doesn't, in a sense, matter what you call it. Global commons is an expression that clearly, for some, has political overtones and cultural overtones and historical overtones. But space is, no matter what you call it, an area that we all have a stake in. Call it what you might. Global commons for some is a convenient thing, for others is not a convenient thing. But the mere fact you don't like a term doesn't in any way negate the fact that space is what it is from a legal perspective. in terms of the 2015 legislation and then the other national laws that followed, you mentioned Luxembourg. Luxembourg, for example, has developed an infrastructure and a capability which has attracted many companies and has promoted particularly space resource activities. The legislation under the Obama regime that you mentioned was the first national law that purported to grant some ownership rights, other commercial rights to American citizens who engage in certain activities. Countries can pass whatever law they want on anything as long as it is constitutional within the country concerned. So ignoring any non-constitutionality, and that wasn't an issue with that 2015 legislation. So the United States was perfectly, and any country is perfectly within its rights to pass any legislation. Note, and many people overlook this, the words in the 2015 legislation, where it purports to give under US law various rights, but then it has some really crucial words at the end. It says, subject to, and I paraphrase, subject to the United States international obligations. The United States is a party to 4 of the 5 treaties. Of course, the Outer Space Treaty, and then the Rescue and Return, and the Liability and the Registration Convention. They're not a party, as everybody would know, to the Moon Agreement. But they're a party to those fundamental treaties. They have been engaged in the development of all of the other instruments that UNCOPUOS has come up with as a foundational member of UNCOPUOS. They are a state subject to whatever customary international law may exist with space. And customary international law, as you know, Susmita, is sometimes difficult to put your finger on what is exactly customary international. But let's assume there is some out there. So there is a whole world of international obligations to which the United States is bound. So whatever it purports to do under its national law is subject to those obligations. The obligations under the treaty, the Outer Space Treaty, for example, and this is just one, under Article 6, is for a state being internationally responsible for national activities in outer space, so that, for example, if an Indian national were to engage in space, depending on the circumstances, but more likely than not, that would be a national activity of India in outer space. It is responsible internationally under Article 6, and part of that responsibility is to, and the word is assure that the activities of the private entity are in compliance with the provisions of the treaty. The United States is under that same obligation. Australia is under that same obligation. And so the mere fact that under national law you give certain rights is one thing, but then to say it's subject to the obligation, we need to determine what the international law is about these things. That is, to a certain degree, the task that the working group that I have the privilege of chairing is engaged in, setting out principles. Some people have said to me that the working group is looking to operationalize the fundamental treaties, the space treaties, when it comes to space resources. So part of our mandate has been to try to work out what the existing international framework and governance instruments has to say about space resource activity, and working out what else needs to be added, as I've said, to those principles. And so focusing on the 2015 legislation, but ignoring the international, is just focusing on one small part of a much bigger picture. You need to understand the international obligation, the international framework, to fully understand what the 2015 legislation is. And to a greater and lesser degree, that is the same with the other countries that have passed laws that other national laws that specifically deal with space resource activity. And of course, the point, it goes without saying, of course, that the national law of any country is only binding on those within the jurisdiction of that country anyway. So the 2015 legislation galvanized the international community into realizing that they had to talk about space resources more. As a result of the 2015 legislation, there was quite robust discussion at the international level, some criticizing the United States, some praising it. But out of that, we ultimately got the issue of space resources. We called it as an agenda item, potential legal models for the exploration, exploitation, and utilization of space resources, put onto the agenda of UNCOPUOS Legal Subcommittee in 2017, so as a reaction to the 2015 legislation. And out of that, subsequently the working group that I chair has been mandated to actually create now additional principles. So the 2015 legislation, it's part of a building of a picture, but it's also subject to the principles in the international law that exists and is being developed. So it's a two-way street.
Clearly, Professor, the unilateralism and minilateralism that's starting to play out makes your job as a chair of a working group that's focusing on resources very interesting and challenging. Has Scopus reached a consensus yet on space resource governance for the moon?
The working group have a mandate which concludes in 2027. As part of our mandate, as well as looking at the existing framework, looking at existing technical issues, as working out what potential gaps might exist. If there are gaps, how do we fill those gaps as appropriate? And part of our mandate is to develop what are called initial recommended principles for space resource activities going forward. And then as the last element of our mandate is for the member states, and our working group is all of the member states of UNCOPUOS, it's 3 or 4 people, for the member states to then work out what's next. So we have quite a complex, systematic working group. The member states, the working group, asked myself and the then chair, Andrei Mishtal, who sadly has passed away, and I am now the chair, to draft the first draft of these initial recommended principles. I did that on my own, following Andrei's tragic passing in January. I did that. They were submitted to member states in March of this year. We then have had a series of either online but mainly in-person meetings, negotiating the wording of that draft of the initial recommended principles that I prepared. My draft was based, as I was mandated to do, on inputs received from the member states and some permanent observers over the previous period. We're now negotiating it. We have another revised draft following the meetings we had in Vienna in May that's being circulated now to the member states. We're going to have a series of intersessional meetings leading up to next year's legal subcommittee. We are moving forward. We haven't reached consensus on those principles, but the aim is to have that agreed by 2027. And it's a complex piece of work because of all of the inputs, all of the perspectives, the sensitivities around space resource activities. It's a very geopolitical, sensitive area. The different aspects, commercial, indigenous perspectives, cultural perspectives, science, geopolitics, all of those issues make this complex. So the hope is that we will reach consensus on these principles in 2027, and then the member states will then also work out what's next, because these high-level principles, because the member states wanted it in that form, is not a legally binding document, because many say it's too early to have legally binding because we don't even know to a certain degree what such activities will look like. And I think that sounds like, to me, a very logical way of addressing it. But if we reach a consensus on these principles, and it is an if, anything can happen. We reach by 2027, the member states will then decide, well, okay, we now have the principles. Do we want to do something more? And they might decide to develop another working group or extend the working group, with other tasks. That's entirely a decision for the member states. But the hope is to have consensus, at least on the initial recommended principle, by 2027. We've made really good progress, but of course the devil is in the detail. These are sensitive issues. There'll be much discussion, much negotiation over the wording, but they have a detailed draft already in front of them. It's a public document, and hopefully civil society is looking at that and then feeding their inputs also to their respective state delegations, and those inputs can also come as another marble into this box of marbles that we're dealing with.
Clearly, countries are one of the primary stakeholders in space, but not the only stakeholders. In the past decade and a half, I would say private companies are playing a very prominent role, and not always without controversy. Recently, a company transported human ashes to the moon, an act that sparked protests from certain indigenous communities who viewed it as a desecration of sacred space. So how are non-state actors, such as communities, people, private corporations, being included in the international space governance discussions through UNCOPUOS and sort of beyond UNCOPUOS?
So there are pluses and minuses to this. So on the plus side, and this is sometimes speaking from an ideal perspective, delegations of countries come to COPUOS, the decisions are made on a consensus basis by the countries. One would hope and expect those countries themselves within their own country would have consultations and discussions with all sectors of their society to get input, which would help them, then the country itself, reflect on their inputs to the discussions of COP. So it's to be fed through the states. Secondly, COPUOS has about 54, maybe the number's not entirely correct, but dozens of what are called permanent observer organizations that, whilst they can't engage in the decision-making, they have a right of a voice to contribute to the discussion. And those permanent observer organizations range from really big ones, the European Union, the European Space Agency, the ITU, etc., to relatively small NGOs on space, and there are multiple of them, and that number grows all the time. So you are getting there non-state actors contributing to the discussion. That's, in a sense, the rosy picture. The negativity, the criticism of COPUOS, is that, for example, unlike the ITU, industry and other aspects of the non-state actors and non-governmental sector do not have the ability to participate in COPUOS. We have the states, we have the permanent organization, so that is non-state actors, but you really don't, for example, have a great ability for industry itself to participate at that multilateral level. Obviously, as I said, you're hoping that industry is talking to its government and influencing what the government contributes, but of course that will vary in every country. So some criticize COPUOS and say that it should be reformed in that industry has a greater possibility to participate actively in the discussion. There are some delegations at COPUOS who vehemently would oppose that sort of extension and emphasize the governmental nature of the decision-making of COPUOS. So you have conflict there. And the ITU, for example, is a lot more open to the operators and industry to participate in many of their discussions. And so there's comparisons made between the two organizations. So the answer to your question is there is certainly scope and there is certainly reality for non-state actors to contribute. But in a perfect world, there could be ways that they would have a greater opportunity to contribute in a more approachable and accessible way. But it's not for me to say that should happen, because a lot of member states believe it shouldn't. But that is the discussion that is being had outside of COPUOS. Within COPUOS itself, this isn't really an issue, except that every year we are getting 3 or 4 or 5 or 6 more permanent observers coming in. So there is a broadening of the non-state actor participation on a formal basis within the discussion, but many argue there could be more.
Finally, a crystal ball question for you. What will the moon look like, geopolitically speaking, in 2050? Will it be a domain of collaboration, competition, or conflict?
Well, crystal balls are always hard. Obviously, from my perspective, and I'm sure from your perspective and everybody listening to this, we want to ensure that humanity is able to garner the benefits of space, not just for our generation, not just for the next generation, but as our indigenous people in Australia would say, for 7+ generations beyond. We need to ensure that this notion of the sustainability of space activities going forward is promoted, is protected, and is a reality. And there are threats to this, but it's certainly a strong part of the discussion. And we have, as you know, in 2019, the long-term sustainability guidelines from COPUOS, which really focus on some of those issues, albeit at a relatively high level. So we would all hope that the moon in 2050 will reflect that understanding that we have to be cautious, we have to respect the fragility of space, we have to understand that we cannot be rapacious and simply see space as something that we exploit, but rather humanity is a small part of a much, 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 much bigger picture, and that we respect our relationship with space, and that therefore, to the extent there are activities on the moon, they are done maximizing benefits for humanity, minimizing risk. The principles that I'm involved in, hopefully, finalizing through the member states, and the member states will decide by consensus, help to promote that in terms of issues of environmental protection, in terms of, or at least environmental awareness, in terms of sustainability, in terms of peaceful purposes, in terms of consultation and cooperation. If you have a look at the general headings that have, by and large, been agreed by the member states in these principles, we still have to delve into the detail of the wording. All of those aspects are included. So all of that points to a reasonably positive future, where we will have, you asked about, I think you said, collaboration. Will it be collaboration, competition, or conflict? I think it'll be, as I said in answer to an earlier question, a combination, hopefully, of the first two only, collaboration and competition. No doubt there'll be competition. But space and the activities on the moon and the nature of these ideas about how humanity wants to expand its realm, it's too big and too complicated for one or two or small groups to actually do on their own. These things require us to work together. We may not necessarily like each other. We may be competing on specific areas, but on those really big issues, we need to work together if either of us or anyone else is to have the chance of an opportunity of delving into some of these activities. So I think there will be, hopefully, if we follow the fundamentals, if we understand the risks, if we seek to maximize the benefit, it'll be a combination of those two. Of course, things can go wrong. But if we were to have a conflict, that would be a disaster for humanity. And there is always this danger. If you look, for example, at the history of humankind on Earth, the vast majority of wars between people on Earth have centered around resources or areas where resources are located. It might be, of course, expressed for different reasons. By and large, it's about resources. Now, if we are talking about space resource activity and utilizing space, we obviously still already use the resources of space in terms of orbits, and very, very much so. But if we now talk about other types of resources in specific areas, we have to be very, very careful and very, very mindful. That tends in humanity's history to raise certain flags that we have to avoid. And so there is always the risk that we could have that third C, which would be a disaster for humanity. But one has to be cautiously optimistic. One has to understand that space benefits us all. Small countries, emerging countries, middle powers, and of course the large spacefaring nations, who have the most to lose if we have a conflict situation, because nobody will win, and their ability to utilize their comparative advantage in their capabilities in space will be decreased significantly in a conflict situation. So we have to hope that people will understand that, and as dangerous as certain rhetoric might appear to be, there is this undertone of an understanding of our place in space and what space has, can, and will do to help humanity survive and hopefully prosper. So one has to be cautiously optimistic, but of course no one can be certain. So my crystal ball, Susmita, is unfortunately a little frosty because we just don't know for sure. But I think it's voices like yours and all the incredible work that you do and many people that will continue to remind us of the importance of not crossing certain lines when it comes to space.
Thank you, Professor Freeland. It was a pleasure.
Thank you so much. I wish you well, and again, congratulations for all the amazing work you do. You're an inspiration to so many people.
Thank you. Thank you all for listening. Stay tuned for our next episode. Refer to our website, spaceportsarabhai.org, for more discussions, debates, dialogues, an explainer series, the new Space India podcast, and a newsletter about the progress of India's space program.